Yes.
Thank you. My lord, my lady, having answered, hopefully, my Lord Justice Lewis's question dealing with the James type point, can I just briefly go back to the detriments and treatment which are the focus of the judgment?
Yes.
And I made an observation at the beginning, not intended to be personally critical, but observing that there's a certain shifting of position from the pleaded position. And it's perhaps just worth noting something about the way that it's being articulated before this court by comparison with the tribunal below. And to do that, can I just take you within the bundle, core bundle, to page 89 within the Employment Tribunal judgment. If you look at paragraph 3 at the bottom of the page,
yes,
we note the following. During closing submissions, the claimant applied to amend the claim and list of issues to include a further PCP. So PCP being an indirect discrimination claim in relation to the case. The PCP was formulated as follows. The respondent's exemption of policy exempting exams set by the IAI. So that's the very thing which he now says is direct discrimination. He didn't apply before the tribunal to amend to claim that that was direct discrimination, but before your lordships, it now seems to be his case. So we can only meet the case that's presented before the Employment Tribunal. We didn't have an objection to that amendment as it seemed there. We felt comfortable with dealing with that as an indirect case, but reformulated, it's presented differently. And the second point to make about treatment, I've already made it in respect of what the treatment is, being 2 stages, because this is a case where effectively my little friend combines things. He seeks to combine the policy that's alleged against the Indian Actuarial Institute of not admitting UK nationals and the policy of having examinations at a different time to those of the respondent. And my Lord Justice Lewis made a point about remedies, and the point works in 2 directions. It's not merely a point about remedies, I respect to observe, it's also a point about detriment, because if one pauses to think, how does one correct the discriminatory treatment of which the complaint is made? Well, my Lord Justice Lewis is right, that in a sense the only way that the claimant can articulate it is to say, well, you must not recognise the Indian Institute's examinations, because the problem becomes the 2 things on which the judgment are founded, admission to the Indian Actuaries Institute, and when you sat the exams, are things entirely outside the control of the respondent. That really only reflects to the fact that the treatment is not treatment, or detrimental treatment, by the respondent. And that's a fundamental point that the EAT correctly identified as being the flaw with the judgment on direct discrimination. Not cured by my learned friend's attempt to reformulate it at this particular level. So we say that ground 1 of the appeal, that the EAT erred in finding less favourable treatment was not treatment by the respondent. The EAT absolutely correctly identified that to be the basis of the decision, correctly determined that the judgment had to be set aside, and on the factual findings that it saw, concluded properly that there was no other conclusion conclusion other than that direct discrimination had to fail. If it's a case about indirect discrimination, or we'll come to it, section 112, which is still maintained as a particular claim. Because what my learned friend ultimately does, and in a sense during the course of argument this morning, he almost effectively acknowledged it, is that he talked about the effect. Well, the minute one talks about the effect of something, one's recognising that one's in the field of indirect discrimination rather than the field of direct discrimination, because what he was rightly articulating was that really his case was to say the net effect of these things together leads to indirect discrimination in the affirmment of qualifications or the terms upon which they're offered. Now,
can I just be clear in my own mind what is being said in terms of the structure of the appeal? I understand the argument that the treatment is not treatment by the respondent if it's membership of the IAI or if it's giving opportunities for examinations. I understand your case on that. If it is a separate issue of the basis for recognition, is your case A, that that's not pleaded and therefore he can't bring it, or B, if we decide it is pleaded, either there's only one conclusion as the tribunal found, or is a different thing, he had to prove it and he'd have to show direct equivalence with all of the bodies, and if he hasn't done it, that's his own responsibility. Do you follow me?
All of the above is my observation, in this sense that, number one, not knowingly giving up on a position in relation to that. Number one, the pleaded case and the judgment was not the case that's being articulated as being discrimination in the recognition of the actual exams of the Indian body. And as I've noted, actually there was an opportunity to plead that as a direct position, and actually it was put as an indirect case. So number one, as a technical point, the appeal against the judgment was correct at the EAT and before this court that there was an error. Second point is, I do take the point that if the court's of the view that it was sufficiently broadly pleaded to say it could be reformulated or argued as being that the direct discrimination was framing it as being recognition as being equivalent the examinations, that we're back to James, and as a point of principle in relation to James, that's not a decision that's directly aligned to, it's not the same as saying age determines on the basis of retirement, which is parallel to gender or protected characteristics.
Well, that's my question. We don't know that. What if every organisation has a rule saying no British people, they ordered like this because they're all post-colonial?
Well, the second point, my second point is that it's not really James. The third point you rightly raise, which is, and I was reflecting on the attention that was drawn to us of the recent Court of Appeal decision in Bowen and the Rural Parks Limited, and I detect from the question that there may be some relevance to that in this context, that as I understand the authority, the pleaded case there was to say that the indirectly discriminatory effect was that the employer, ultimate principle, paid differentially between all of the direct workforce and its contractor workforce. But at the tribunal, having pled that particular case, the evidence that was led evidence about the ethnic composition of the direct workforce, but only led evidence of a subset of that particular group. And the Court of Appeal said, I know, my Lord Justice, as you're a member of the Court of Appeal, but and concurred with the judgment of Lord Justice Underhill, said, well, your opportunity was to make the case that you advanced, and you didn't make the case you advanced because you didn't lead the evidence to substantiate that. Now, that sort of feeds into my second point, which is to say, what's the decision here? The decision is to recognise equivalent exams if you're going to make a case to say that that is even indirectly discriminatory, or indeed if you're going to say it's so aligned to a protected characteristic of race that in fact it becomes a synonym for race, you're going to have to show evidence that it's completely aligned across the piece. And there wasn't evidence to show that.
And we shouldn't send it back and give him another chance to do that.
No, and that's the second interesting point about that judgment, which is that as I detect it, when it came to how the appeal should be dealt with, the claimants in that case were effectively saying, let us go back to the tribunal and rethink the evidence that we want to advance on indirect discrimination. And the approach of the Court of Appeal was to say, you had your chance to make that case, and the fact that you didn't make that case rests at your door. You can't then have another go at that particular cherry. I mean, it's always been a slightly interesting thing to me that that before the Court of Appeal and the EAT, in employment cases, it's quite often the case that matters are remitted back for rehearing. But in the more general appeals against other civil judgments, putting to one side the family division where one does see remission for rehearing, actually in civil trials, often there isn't a remission for rehearing. It's a more common route in the tribunal, but equally, it's only obviously exercisable if something has gone wrong in the legal analysis rather than something gone wrong in the way that someone's chosen to present their case. And that's how I understood the Court of Appeal approach in the case, was to say, well, it wasn't a question of the law being wrong, it was a question of what you chose to make that good. So I think all three really for me, pleading, never an attractive point, but I say quite clearly here, a different case was being advanced in judgment, erroneously so on technical. Two, it's not really a James case because the decision is a decision that's operative about equivalence rather than something which is directly related to protected characteristic of race. And three, even if you were going to say that, you need to show that the totality of the evidence established that it was 100% the case that equivalence aligned in some way with race. Otherwise, you're really into indirect, which I acknowledge was being run and has been remitted for rehearing. I don't think there's any more I want to say about the first few parts of my appeal. The comparator point, sorry about the response. The comparator point, which is ground 3. I'm sorry, ground.
Yes, isn't it?
I do apologise. It's ground 5. My learned friend was light on. Not really surprising. Doesn't really help you very much with the comparator position. Indeed, slightly ironically, the comparator actually rather makes the point against him because the comparator he identifies is an Indian member of the respondent. Well, in terms of the treatment that they're afforded by the respondent, they have exactly the same opportunity to sit exams as the claimant did. All he can say is they've got the opportunity to go and join the institute in India, and then the opportunity in the institute in India if it maintains its policy of having exams at a different point in time. But from comparison purposes, for the purposes of treatment, it doesn't take you anywhere. And in fact, what one does recognise, of course, when one comes back to the James point, is that just as he has, the Indian member of the respondent could go and take an equivalent examination in America, Australia, or anywhere else and say, well, I've got the opportunity to do that. So you're back to the same fundamental problem that he's got. So he's right to say that comparators are he's right to not spend long on it because it really doesn't help him. Which brings us to paragraph 6, which it's interesting to hear someone say that they want to amend their appeal at the end of their submission before the court. Not least because I haven't even seen a draft proposed amendment appeal, and one has to step back and recognise this. Ground 6 is relating to a challenge.
I think you.
It's ground 4. I'm sorry.
It is.
I don't
have a ground 6, which is
I
what
do apologise. It's
alerted me.
ground 4 on page.
It was ground 3 previously. It was the comparator.
Yes, I'm sorry. I do apologise.
It's all right, don't worry.
It's dealt with in our skeleton argument. I am sorry. It's in the core bundle in our skeleton argument, page 47, and it's 6 was our numbering. It's ground 4. I'm sorry.
That's right. Yes.
And it's his case about impermissible interference with a finding of fact.
Yes.
And the first observation to make is the finding of fact that he is referring to is a finding of fact that relates to an agreement with the Indian Institute, which is said to have barred UK students. Now, that has no material relevance directly, the agreement fact, to the question of direct appeal. And one slightly wonders how it can be said. I'm sorry?
Direct discrimination. I'm so sorry, I just didn't understand what you just said. You said it has no relevance to the direct appeal. Do you mean direct discrimination claim?
To the direct discrimination claim, yes. It has no direct relevance to the appeal, which is only, as that's presented, against the direct discrimination judgment of the AT, overturning that finding. The agreement...
To be fair, Mr. Jupp drew our attention to paragraph 9, which said the determination of this factor of dispute was of considerable significance in all of the claims. And if there wasn't an understanding, policy, arrangement, call it what you will, that British people can't join the IAI, the direct discrimination case couldn't get off the ground anyway.
I'm sorry, but we have to be quite careful about that. Two things. There's the policy. I absolutely agree that the policy was instrumental to of non-admission of UK citizens, and then there's the agreement to affect the policy. They're slightly different points, and I absolutely accept, and I would rely upon the fact that the EAT were observing that those two things were instrumental to the way the claims were being advanced. The agreement aspect wasn't a necessary component of direct discrimination. As it doesn't appear to feature anywhere.
But isn't one reading of the situation and the judgments this? Because the British wanted to engineer a situation where there was no competition between, the materials they provided in India weren't seeping back into the British market. The understanding arrangement, quid pro quo, was that Indian nationals, British nationals wouldn't be allowed to become members of the IAI, and the policy isn't in truth a separate unilateral act the Indians think is a good idea. They've adopted, in inverted commas, that policy, really, as a means of giving effect to the fact that there's a kind of non-competition agreement between the British and the Indians. I haven't put that clearly, but I think that's what Mr. Jupp is in part saying, or could be said.
Could be said. Well, even if the two are aligned together, and I do think that they fall apart on the way that the judgment has been appealed as part of that necessary finding. I suppose my primary observation is, which we just need to be clear about, is that the only appeal that's been entered is against the direct discrimination finding. So if you're with me on the conclusions that we say that the AT was right to reach, then it's actually quite hard to understand what freestanding basis there is for the other aspects of the appeal, in particular ground 4. And one only needs to pause to think about this, about the powers of the AT, and we need to look closely at what the AT were doing here, is that the order that's appealed against is at page 53 of the bundle. And paragraph 1 is the subject of the appeal. Paragraph 2 is the remission. That's the indirect claim. And the area we're looking at here is paragraph 4. Paragraph 4 of the judgment of the Employment Tribunal is set aside and the claim remitted to a differently constituted employment tribunal. Now, on the face of the order, the setting aside of paragraph 4 of the judgment, which you find at page 84, sets aside all the factual findings for the basis of that judgment. I mean, if the judgment is set aside, then the underlying factual findings fall apart. Although it was open to the EAT, and I appreciate that there will be experience of sitting in the AT, it's open to the AT to set aside a judgment and remit back for tribunal, either to the same tribunal, of course, or to a different tribunal, but to remit back on terms identifying particular issues which will not be to be determined again. And my learned friend is not grappling here with something that was novel, because we'll look at it and we'll see that actually the terms of the reference back were argued extensively before the EAT, and the judgment that's made, which has that effect, is not the subject of an appeal. I don't really understand my learned friend's proposition that in some way he couldn't appeal a judgment that said remitted, that set aside without any limitations of remission. He wanted the remission to have defined factual findings still biting. And we just need to track through briefly that, of course, what happened with the EAT is that although we have the final version of the EAT judgment, it's sent in draft to the parties before that conclusion in order that they can address issues around disposal. And what they saw is the EAT having doubts about the findings, both in relation to the agreement and the policy. And you find those, if we go to the EAT judgment in the core bundle at page 65 from paragraph 38. The claim under section 112 was the bit that's the fourth element of judgment, and we haven't really focused on it, but what the EAT had found is that the tribunal had confused the requirements of section 111, section 112, and failed to recognise that what you needed to show was that there was an unlawful act for the purposes of the Equality Act on the part of the Indian Institute, and then you needed to show for section 112 knowingly aided and abetted by the respondent. And at 38, His Honour Judge Taylor was considering, having allowed the appeal in relation to section 112, that it would have to be remitted for determination. And one of the issues which has arisen is, well, there's an issue of territorial jurisdiction. Did if the Indian Institute had that policy, is it a policy that involved a breach of Section 53 under the Equality Act? Is the reach of the Equality Act one which embraces that? Now, that was a point that the tribunal had failed to address in the way that it was dealt with below, because it had failed to recognise that in order for this bit of the claim to work, there had to be a freestanding breach of the Equality Act by the Indian Institute. And His Honour Judge Taylor also recognised that that involved the prospect of a serious finding against the IAA, because it would involve a finding against it that it had acted unlawfully under UK law. And one of the things which hadn't been considered that caused him concern, and you find it over the page on paragraph 40, he's expressed his concerns about the determination that there was an agreement between the respondent and the IAA that meant there's an absolute prohibition. So he had some concerns about the factual finding, but noted that there was limited scope for the IAA to provide any evidence in circumstances in which the IAA was not a party to the proceedings. And the claimant asserts the IAA acted unlawfully. So one of the things he noted on remission was that it would have to be open for the IAA to choose to be given the opportunity to take a part in the proceedings. Now, if one paused to note there, really, the minute one's recognising that, it's obvious that all the factual findings have to fall away about the policy and the agreement, because it wouldn't be bound by those. It was never a party to the original judgment. It's coming as a party to argue the particular point. And we see this being picked up again at page 70 in the core bundle, paragraph 52. So we've looked at the original bit was 112 and why the tribunal had erred in that approach. Then the section looks at direct discrimination that we've been focused upon. And then at paragraph 52 on page 70, the EAT picks up both parts and says, as we set out above, the parties should be given an opportunity to make submissions on disposal, were disposal to involve remission to the Employment Tribunal, and the analysis on remission relies on the claimant establishing that there was a total bar on UK nationals joining the IAA. That raises a question of the safety of the employment's determination that UK nationals are not permitted to join the IAA. So he's back to the point that he's not happy with these factual findings, but importantly, remission to rehear that point, with the IAA having the opportunity to be engaged, is going to have to reopen those.
I'm not sure why the IAA have to be engaged. I mean, if I say two people beat me up and I want to sue them each for damages, I might decide, you're the one I want, you've got much more money. So I might say to myself, well, I'll sue you. And it may be that statements are made in the course of the tort claim against person A that you did it with person B. That doesn't mean you can't find wrongdoing on the part of person A.
Well, I don't disagree with that.
It wouldn't be binding on the Indian Institute.
I don't disagree with that proposition, other than what His Honour Judge Taylor is recognising is that the IAA had to have the opportunity to be engaged. Now, I agree that if, in fact,
Why?
To have a finding against it as an international recognition body for actuaries that it had discriminated in the UK, which is a necessary part of Section 112. I mean, I observe that it might be thought that someone having a finding against them, an unlawful act in the Equality Act, might at least involve the opportunity for them to have the opportunity to argue the contrary, even if they don't take it up.
And even if they're not bound by it. Even if they're not bound by it. Because it was very interesting that they sued and so on, but it's nothing to do with us. We weren't a party. and that's their view. But I mean, why, if you want to sue person A, must you sue somebody else who might have got caught up in the wrongdoing?
No, I go back to my previous answer. I'm not saying you have to. What he was saying is that he wasn't comfortable with the remission without having had findings against them, that there wasn't case management contemplating that they be given the opportunity. It wasn't a question for the claimant. He didn't have to. He didn't have to join them as a party. I accept that. But under the tribunal's case management powers, it has the ability to invite or join other parties if they wish. And what he was observing is the invitation to them wasn't extended to choose whether or not to contest an allegation.
So what they're doing here then, it's not a ground of appeal that the IAI wasn't a party. It's simply saying I'm remitting for other reasons, but I'm exercising, or I'm saying what would be a good thing from case management. What's the basis of his decision then, that he's remitting this?
The basis, the basis of his decision is that he's set aside, he's found that the tribunal have erred in their approach to section 112 because they failed to recognise that it was necessary to make two specific findings, one of which was a breach on the part of the IAI of the Equality Act. Now, accepting that they didn't have to be a party to find that, but that's what he found. And he's found that the tribunal have confused themselves about how those sections operated.
So what you're saying is he decided to remit, and he effectively decided that there should be no, as it's called in some jurisdictions, preserved findings.
Yes.
Relating to that issue, and it should be redetermined.
Yes.
And you're saying that decision has not been appealed.
Yes, and you put it succinctly. That's exactly what I'm saying. And if you look at the supplemental bundle, having invited arguments about this, you find at tab 1, in the supplemental bundle, page 3. These are the parties did submissions on how disposal should work.
Yes.
And just for your reference, each party did primary submissions. Claimants are at tab 1, respondents at tab 2, and then they each did responsive submissions to the others, and those are at tab 3 and tab 4. And if you look at the respondents, if you look at the claimants' submissions, which you find on, I should say it's confusing because it refers to them as respondent as they were before the AT, but they're the claimants' arguments at page 5.
Yes.
You'll see that exactly as my learned friend articulates it from paragraph 10 on page 5, he articulates the argument that any remission should not involve setting aside the factual findings, because he specifically refers to those findings not being challenged. That's his case. And he addresses the question of whether or not the IAI should be joined and his order on remission. So what he asked for is at paragraph 14 on page 7. Claims 1, 2 and 4 should be remitted to be reheard, save that the factual findings set out L49 to 81, including 80 that he's relied upon, and L166 on the issue of the IAI policy should not be reopened for reasons set out above. So he was absolutely clear about what he wanted. Equally, we were completely clear about what we maintained. Our case had been that we challenged on the basis of perversity conclusions. That was paragraph 11. And if you look at the respondent's submissions, you can see on page 9, we take a contrary view. At 1.2.1, our position is set aside judgment for and remit to a new tribunal to consider it afresh, i.e. everything falls away. And we repeat that at 1.422 on page 10. Rehear the evidence relevant to the finding of fact that the IAI had an absolute prohibition on British nationals joining the IAI and that the respondent and the IAI had an agreement to that effect, and redetermine those issues referred to in 64 of the draft judgment. So that was our position. Repeated again, it's in our skeleton argument at 6.6 on page 49. So all of that was argued in front of the EAT, and the EAT reached conclusions on it as part of their judgment. And that judgment, appearing in 77, I really should start at 76. Paragraph 64. This is where my learned friend is critical. The finding that the respondent and the AII had an agreement under which an absolute prohibition on British nationals joining the IAI. This case may have to be remitted for determination subject to any submissions the parties have to make on disposal. That brings into focus my concerns about the safety of the factual finding, and the respondent and the IAI had an agreement under which there was an absolute prohibition under British nationals joining the IAI. Should remission be appropriate, my provisional view is that the revised grounds 9b and 11 should also be remitted for determination. Ground 11, which is at 124, is the respondent's challenge on the basis of perversity to the tribunal's conclusions about the policy. So it's absolutely clear that that was being challenged. It's clear that he's inviting submissions on what should happen. And then, having seen the submissions that I've just directed your attention to, he makes a decision. And that decision is from paragraph 66 through to page 78. The relevant part being paragraph 70 on page 78, where he records that there's a dispute. This is at paragraph 70 on page 78. There's a dispute as to whether on remission, the question of whether there was an agreement between the respondent and the IAA, that UK nationals would not be permitted to join the IAA, will be open for fresh reconsidering. I accept the respondent's submission that this finding was challenged on the appeal. In the appeal. That's the ground 11 challenge. I consider the finding of the Employment Tribunal on this issue is unsafe. The Employment Tribunal analysed section 112 EQA complaint on a fundamentally flawed basis, and that it treated the basic convention as having been committed by the respondent. That was their error of law. If it appreciated that the basic contribution had to be committed by the IAI, it would necessarily have had to consider how the issue could be dealt with in a manner that was fair to the IAA as well as the respondent. I consider this factual matter should be redetermined on remission. It will be for the Employment Tribunal to consider any application by the IAA to be joined in the proceedings and whether or not the issue of territorial jurisdiction can be raised. So he's heard the arguments between the parties. He's made a judgment that the better route, having set aside that, is to remit for a complete rehearing. And there's no appeal against that judgment. My learned friend could have appealed if he wanted to. It's not that it wasn't argued, it's some side wind. It was completely argued and he hasn't chosen to argue it. So the short answer to that ground of appeal is it doesn't really run when you look at the way the case has been advanced. It's an attempt to engineer by a side wind an attack on a judgment the EAT were entitled to make on remission on a part of the judgment he has not appealed. So, from our position, I might in a moment just crave the indulgence of speaking to my learned junior who appeared in the EAT and knows the case better than me. But from our position, my submissions are, we say, clear. Number one, the EAT was right, the tribunal were wrong in confusing detriments in this case, and it was never a direct discrimination case. It was always, if anything, an indirect discrimination case. There's an unappealed judgment setting aside the tribunal's error of approach in relation to accessory liability under section 112, and an unappealed decision to remit that for a complete fresh hearing before a new tribunal where the parties had completely argued whether or not that should be fettered by any remission relating to the facts. And my learned friend has not challenged the decision to remit without such a fetter.
I just very, very quickly looked through, not having focused on it before, the basis upon which the appeal is allowed in relation to section 111 EQA. And that appears to be in part, if you look at Article 29 and at 34, it says the judge is very worried about making a finding that a professional body in India was acting unlawfully and so on. So the starting point is that he decided, in considering the claim 4, to allow it for various reasons, including his view of procedural fairness. And he then went on to decide to remit everything. And your argument is they'd have had to appeal the ground for the claim for finding, and they haven't. And the remissal, even if we don't think it's a good or a bad argument, that's what the EAT did. And if they feel that there was an error which was to be set back because of the unfairness, that should have been appealed, and the appeal should have been there was no procedural unfairness, they weren't a party and didn't have to be.
Yes.
It's not just the remission, but putting it shortly, it's not just the fact it's considered on remission, it's the underlying reasoning for allowing the appeal in relation to claim 4, and that hasn't been challenged, is what I'm trying to say.
None of it's a subject of challenge, no. And so, as I say, this is an attempt to lever something in that isn't fairly before the court. If I might have a moment, I apologise.
Yes, of course.
Yeah, that's it.
So Ms. Collingwood makes the point to me that it's really the point I made earlier on, that this is never featured in the appeal, because on the direct claim, the EAT allowed the appeal on the direct discrimination claim on grounds 1, 2 and 3. Yeah. And the challenge to the findings in the agreement were on ground 11 and ground 9. And 1, 2 and 3 are therefore what this appeal is challenging. I'm grateful to her for making the point. Hopefully I've articulated it clearly. Thank you. I'm conscious that I've gone 5 minutes more than longer, but I suspect that's an indulgence you'll let me have.
Yeah, thank you very much. Yes, Mr. Chubb.
Well, I've got a few short points in reply, and I'll just take the last point first. Because I'm somewhat troubled by the way this is being dealt with by my learned friend. I accept entirely that the finding of fact in relation to the agreement was relevant, obviously, to claim 4, and that's what the EAT dealt with. We've appealed the direct discrimination claim. The finding of fact in relation to the agreement, as my lord has observed, is not centrally relevant to that claim. But the finding of fact relating to the policy is an essential part of the claim. So if we split the two, there's the agreement on the one hand, and there's the policy on the other. We're being criticised for not appealing claim 4 for very good reasons. There were other reasons why that claim wasn't viable. By the same token, the respondents have not cross-appealed and said, by the way, if the claimant wins on its argument, we want the matter remitted to reopen the factual finding on the policy, which is what they ought to have done. Because if we don't get to the position, if we're just we can see it from the EAT judgment, which has just been addressed, the remittal is concerned and the argument was concerned, certainly recorded in the judgment, around the agreement. There's no remittal of the policy as a standalone issue. And so if this appeal succeeds, it can only succeed if that finding of fact relating to the policy remains.
Sorry, I don't understand that, because you said that ground 4, the finding, was not a necessary part of the Claim 1 appeal. It is a freestanding issue, and it's supportive.
Yes, there's two issues of fact. One is the agreement.
Yes.
That is not a necessary part of the clarification.
And the other is the policy.
Essential part of the Claim 4 claim. The policy is an essential part of this claim.
Yes, but it's not being said that your appeal from against Claim 1 must fail because, as I understand it, because the EAT has set aside all the findings for the purposes of determining the remitted claims.
Well, that is my understanding of the position. My point is, if that was, that is exactly my position, that in relation to Claim 1, the claim related to the policy stands because there's been no cross appeal in relation to the policy. So I don't need to trouble the court further.
I've misunderstood it.
I'm not sure I understand it actually. In Claim 1, say well, if you win, you're fine. But say you lose on grounds 1, it wasn't the treatment of the respondent, or in grounds 2, it's not by reason of race, it's by reason of a policy of equivalence. Then that's the end of it as far as Claim 1 is concerned. You might have won on both of those, and they might be kicking themselves for saying we should never have challenged the policy. But would it matter? Once it's gone, the finding on discrimination on ground 1, it's gone. Are you saying you can preserve the factual finding on the discrimination claim where the claim has failed for the purpose of using that policy for a different claim which has been remitted back? That's what I don't understand.
Well, if we fail in this claim, the matter continues as is, remitted back, and on the Employment Appeals Tribunal, the matters are reopened. The difficulty, if it is difficulty, I don't think it's a difficulty for us, comes if the claim succeeds. If this claim succeeds, one of the central elements of this claim, in order for it to succeed, is that the IAI has in place, or had in place, a policy of excluding UK nationals. It can only succeed if that is the case. If that's the case, and this court upholds the Employment Tribunal's findings on that, then that factual matter cannot be reopened in relation to the Claim 4, or indeed, if it's relevant, I don't necessarily think it might be to claim, well, there won't be another claim because that'll fall away.
That sounds to me like the following. They can only win on the direct discrimination claim if they win either on who did the treatment, or on was it on grounds of race, or on comparator. They can't and shouldn't be allowed to win on the grounds that in any event there's no discrimination, because the premise underlying it is that British nationals aren't allowed to be members of the IAI, and therefore we shouldn't, it seems to me, be deciding, we shouldn't be deciding that issue on this appeal.
Precisely.
Right, I understand it now. I'm sorry to be slow.
That's fine.
It's late in the day and we're very old.
That's the first point.
Sorry, I'm very old, not my colleague.
That's the first point. The second point, and as I understand my learned friend's submissions, there appears to be a measure of agreement between us on ground 2. He, as I understand it, accepts that if our argument is correct, that you confine consideration to the examinations and of the Indian Institute rather than a generic across-the-board examination, then there is exact correspondence. Equally, we accept that if this court were to find that actually you have to look across the board at the exemption policies across the board, this would be an indirect discrimination case. We can't get away from that. So it turns on this issue of whether we are correct when we say that you should be looking at the IAI in isolation. In other words, and just to pick up a point my learned friend said, you'll be assisted by that, we submit, by looking again at section 53, the arrangements conferring a relevant qualification, and then reading paragraphs 40 and 42 of the judgment. Because what paragraphs 40 and 42 do, paragraph 40 makes it clear that there are a range of MRAs with different institutions.
Yes.
And paragraph 42, which we submit is critical for this analysis, makes it clear that there is a specific MRA with the Indian Institute from recollection based from 2005. In other words, demonstrating that it is individually negotiated. And that tells you, we say, that you cannot look at another MRA which may have completely different terms, maybe a completely different rationale, and read it across in relation to the application of the Indian MRA. You look at each MRA individually, and you look at this one and you can see that respondent has entered the MRA, and then 43, the respondent's exemptions for students, and it has specific, it's very detailed, it has specific dates when exemptions will apply from and won't apply from. And we say that's critical. It doesn't allow a reading over of the generic exercise.
Doesn't it depend on how you define the treatment? And if the treatment is at a high level recognising equivalent exams, the fact that at different times and at different dates different exams are or are not recognised, that's one thing, but you'd have to ask yourself whether the proxy, the aligning characteristic was when they have these arrangements for recognition, the one thing that's absolutely clear is it's a way of stopping British nationals having more than 2 goes.
Well, I think, if I may say, my lords, putting it a little high, the position is we submit that the position is that in relation to the IAI, if you look at that individually, you simply say, why is it that the British student didn't have the opportunity of presenting himself with an exam to get an exemption through the IAI?
That's the matter for the IAI. They haven't let them join.
Yes.
From the point of view of the recognition, the question is, why do they recognise people? And the answer is, because the exams they've been allowed to take are the same as the ones that we set.
But if you're not allowed to take the exams because of the nationality bar, we say that you're definitely, if you're looking solely at the IAI.
Yeah, but that's the question. Why should you look solely at the IAI? Because the policy isn't to recognise Indian exams, and then you say, well, why do they recognise Indian exams? Oh, because there's no threat to our competition, they don't let the British people in. That's not the position. They recognise exams where? California, Australia, I think South Africa. And then the question is, well, why do they do that? One answer might be they think they're as good as ours. But another answer might be, no, you look at all of these, everyone has got built into it a clause that says no British here.
Well, we haven't brought claims in relation to anybody else, but in relation to the IAI against whom we have brought a claim, we submit that it comes that each of the MRAs is an arrangement. They're not single arrangements. There's not one global arrangement with all bodies around the world. There's an agreement we'll recognise all of these types of exams. There is a single arrangement with the Indians, there's a single arrangement with the Americans, there's arrangements for the people. And Section 53 is about discrimination in the arrangement of conferring a relevant qualification. And if you're looking at arrangement in that sense, we would say, you must surely be looking at the arrangement that is made with a specific body.
If there are no arrangements A makes for deciding upon whom to confer a relevant qualification, and the answer is the arrangements are that you pass our exams or you have an exemption from those exams.
But you say it's narrower than that. You have to look at
Each
one individually.
Exactly.
Right.
And the reason you have to look at individually is because they're different in their terms.
Yes.
Next point is a correction that I think something well, no, sorry, before I get to that, the point about needing to amend, below that is, I resist this. It is said that there was an amendment, and it's correct, to add the PCP, which is on page 85 of the judgment. That is correct, but there was no need, we submit, to amend the claim because, the direct discrimination claim that is, because that claim was actually perfectly well articulated both both in submissions but also in the list of issues, again, which appears at 85, because if one looks at turn the page over. If one looks on page 85 in the first bullet point, what is the less favourable treatment? We see the exams which are recognised by the respondent, and then that is the finding that is made at paragraph 141 rather. Tribunal found the respondent treated less favourably than Indians apart from John because he was unable to sit those exams and gain those exemptions. So that is, it didn't require amendment, it was plainly there for everyone to see. The final 2 points I make are related. Firstly, I think I said earlier in my submissions that the claimant is still a member of the respondent. He's no longer a member. He's resigned his membership because of what he says is treatment by the respondent. My final point is, and it comes back to a point my Lord Lewis was making about remedy. I would urge the court to be cautious, indeed not to speculate on the remedy point, because I understand from the claimant that the position which was in fact reached following this litigation was that there was a temporary cessation of recognition of the Indian exams, but then a deal was done following assurances given by the IAI that British students would be entitled to join. And if that is right, and that's what he understands the position, then it obviously means that what I was asserting earlier on in my submissions about the commercial realities of the case appear to be correct. Now, I'm hesitant about it. I've not seen the underlying documents, but the reason I raise it is to invite the court to be cautious about going down, saying anything about remedy when we don't have relevant information before us.
Thank you.
Those are my submissions. Thank you for bearing with me.
No, thank you very much. Thank you all very much for your respective submissions. We will be reserving our judgments, and they will be provided to you in draft in the usual way for the usual purposes, i.e. typographical errors, and not for broader dissemination or use. And we would hope once you have them, you will be able to agree a draft order, but if not, we'll deal with it on paper. So thank you again for your comprehensive submissions. Thank you.